Hi everybody, it's Walter, your mobile historian and blue-collar scholar. So with my background in con law, I've got to give my insightful 2 cents on the Supreme Court's decision in the Dobbs case on June 24th, reversing Roe versus Wade and Planned Parenthood versus Casey. I'm almost 37 years old at the time of this recording, and never in my life did I ever think that the Supreme Court would reverse Roe versus Wade in its entirety. I mean, don't get me wrong, the court has been rolling back on the protections of Roe, for decades, since it was handed down back in 1973. But I never thought, honestly, that they would be bold enough to completely gut the decision. I mean, that's a step that is monumental indeed whenever the court decides to reverse a long-standing precedent, regardless of whether or not you agree with it. Same when the court reversed Plessy versus Ferguson with Brown versus Board of Education. So Roe versus Wade was the law of the land in the United States from January 22nd, 1973 until its reversal by the Supreme Court in the Dobbs case on June 24th, 2022. So almost 50 years, Roe versus Wade stood as the law of the land, okay? And like I said, in numerous cases since that time, the Supreme Court has restricted, the accessibility given by the original Roe decision, but it has never come to the point of wholesale reversing the Roe versus Wade decision. All right, it's a really, really serious moment in U.S. constitutional law. So the original Roe decision was written by Justice Harry Blackmun in 1973, and it was a 7-2 decision with only then Associate Justices William Rehnquist and Byron White in dissent, okay? And for the record, we have no surviving justices that were on the court at the time Roe was handed down 50 years ago. The last justice to pass away who was on the Roe Court of 1973 was the late Chief Justice William Rehnquist, who of course died in 2005, all right? And we currently have several living former justices, Sandra Day O'Connor, Anthony Kennedy, and David Souter, all right? So their opinions on the matter I would love to personally know, all right? But in any case, so with the Dobbs case, the Supreme Court gutted Roe versus Wade completely. We're back to the drawing board. Essentially, states now have the same latitude they did back in 1973 to completely and entirely regulate abortion as they see fit, all right? Now, for women in the vast majority of states, I would like to rightly argue that not a lot, if anything, will change, including my own state of Maryland. As a matter of fact, in most blue states, abortion access will likely increase due to the reversal of Roe versus Wade and the adoption of a significant amount of restrictive laws on abortion in many red states. All right, certain red states already have trigger laws in effect, all right, which have effectively put their anti-abortion statutes back into full force now that Roe v. Wade has been overturned, all right? So the immediate effect of Dobbs, like I said, is to simply return the power to regulate abortion back to the states in its entirety, okay? Contrary to what some people, pardon the noise, might believe, the Dobbs decision does not say you cannot get an abortion. In no way, shape, or form does it say that, okay? The Dobbs decision simply says, and I'm not trying to downplay it, but it simply says, and again, pardon the noise, that abortion is not a constitutional right in the United States, all right? The court used a very originalist perspective in interpreting the Constitution and holding that, quite simply, that abortion, like many other aspects of American society, is something best left to the states to deal with according to their own personal inclinations. All right. So to alleviate any confusion, the Dobbs case does not say to any woman you cannot get an abortion. And again, I'm not trying to downplay it, but the Dobbs case does certainly open the door for women in many of the states to find it much more difficult, if not nearly impossible, to obtain an abortion. Therefore, it is now the responsibility more than ever of the people of the states to protect the right to an abortion. Okay? If this does not galvanize the people, then I don't know what will. Okay? Abortion is now fully in the hands of the voters of all the states to regulate according to their own personal perspectives. All right? Roe versus Wade is gone. And for all intents and purposes, it exists now only in the memories of all of us who were alive, okay, for its entire existence. Oh, well, I wasn't alive in 1973, but for those of us who rather were alive during the existence of Roe as a decision. Okay, so like I said, ladies and gentlemen of all 50 states, it is now in your hands to make sure your legislators, all right, protect that right, okay, because that's the only way it's going to be protected. Now, the court has spoken that abortion is no longer a recognized constitutional right. Therefore, it is now something the states individually must protect. It is to be done in the same manner that you as a citizen of a state protect any other right that you may cherish and hold dear. So with that in mind, keep on this, folks, and protect that right. So I thank you so much for tuning in today. And like I said, I hope I have educated you at least somewhat on the status of abortion and Roe versus Wade and the Dobbs decision, and that you understand that abortion now must be protected by the state legislatures. It is no longer recognized as a constitutional right, and therefore it is completely in the hands of the people to preserve. Thanks so much for listening and tuning in, and I'll talk to you at the next video. If you have any questions, leave them down below and I'll answer them. Have a blessed day and stay warm, stay cool out there rather. Peace.